The number you have reached, 911, has been changed to a non-published number.
Next we have procedure, and we're going to start with pretrial and then start there with jurisdiction. The immediate result doctrine, Goebel against Commonwealth. Traditionally, the immediate result doctrine is, if you're standing in Kentucky, you shoot across the border and you kill somebody in Virginia, you could be tried in Virginia for that murder. Okay, that's the traditional immediate result doctrine. Okay, they talk about, and they go through, the case law on this. In Virginia, the immediate result doctrine means that if the criminal act is partially completed in Virginia, there's jurisdiction in Virginia to prosecute the crime. Therefore, if the case where, if the shooter was standing in Virginia and he shot somebody in Kentucky, he could be prosecuted here. As well, if he was standing in Kentucky and shoots the person in Virginia, he can be prosecuted here in Virginia. So that's the way the immediate result doctrine works. This was a case where a guy was selling, animal parts, antlers, etc., through eBay, and he was operating out of Virginia and setting up his eBay account and everything through Virginia, getting the money in Virginia, but the actual parts of the animal were in Pennsylvania and were getting shipped from Pennsylvania. And he tried to claim, look, I'm not trading anything in Virginia. And they said, no, immediate result doctrine. You did part of it in Virginia. You're guilty for all of it in Virginia. Let's move on to the trial. Jury selection. And this part's about witherspooning. For those of you who don't know, witherspooning is trying to get people off the jury who are anti-death penalty. And this is about a juror who says that she would have to be 100% certain, beyond a shadow of doubt, before she could impose the death penalty. The Commonwealth moves to strike that person, even though she said, yes, she could consider all possible punishments. She just had to be 100% certain to impose the death penalty, beyond a shadow of doubt, certain. And the Commonwealth moves to strike her. Judge does. Defendant objects, saying, look, she said she could consider it all. And court, not surprisingly, the Supreme Court upholds that, says, look, that's a valid strike for cause. The standard is whether or not, if she acts according to her answers, it would substantially impair the performance of her duties as a juror, under the court's instructions. In that sense, the court's instructions are going to be beyond a reasonable doubt, not beyond a shadow of doubt or 100%. Well, then she has stated something that would keep her from being a serviceable juror. Affirmative defense. And again, we go back to Goebel against Commonwealth. And in Goebel, now this is about limiting languages in a statute. You can be found guilty of larceny if you take something with the intent to permanently deprive someone thereof. And then, unless you steal a piccolo, right? Question is whether or not the Commonwealth attorney has to disprove the limiting language, or the defendant has to present an affirmative defense. Now, to determine the nature of this limiting statutory language, who has to decide, who has to prove it, the court has to consider the intent of the statute, the ability of the respective parties to actually prove what needs to be proven, and there are 4 factors that are considered in that. The wording of the exception and its role in relation to other words in the statute, whether in light of the situation prompting legislative action, the exception is essential to complete the general prohibition intended, whether the exception makes an excuse or justification for what otherwise would be criminal conduct, and whether the matter is peculiarly within the knowledge of the defendant. Basically, all that boils down to is this. Is it something that the Commonwealth can prove, or is it something that would be impossible for the Commonwealth to disprove, and therefore is something that the defense has to prove? That's what it boils down to at the lowest common denominator. Closing arguments. Blanton against Commonwealth. An objection to a statement made by the prosecutor in closing arguments does not preserve the error unless the defendant moves for a curative instruction or mistrial. So if you object to something the prosecutor says, you have to both object and move for a curative instruction or a mistrial in order to preserve that error. And of course, when a mistrial motion is made, the court must determine, considering the entire case, whether the defendant's rights are so indelibly prejudiced as to necessitate a new trial. Andrews against Commonwealth. Again, it's the same thing I said before. Since the defendant is forbidden to introduce conditions of prison evidence, the prosecutor is forbidden to argue that in closing arguments, or anywhere else for that matter. Well, ladies and gentlemen, that's it for this week's Crim Law TV. Next week we'll see what's up. I'm not sure what I'll be talking about then, but y'all have a good week now.